On one level, no. On another level, yes. So the term adversary proceeding is the term we use to describe a lawsuit in bankruptcy. And so pretty much all lawsuits follow a certain pattern. There's a structure to them. Now, the underlying theories, however, can be quite different. For example, perhaps one of the most common type of adversary proceeding in the bankruptcy court is an adversary proceeding to either challenge the discharge of a debt or to determine that a debt is dischargeable. So in the realm of challenging the discharge of a debt, in an individual case, this doesn't apply if the debtor is a business. In an individual case, there are some kinds of debts that are not dischargeable. The complete list for chapters 7 and 11 is found in section 523A of the Bankruptcy Code. And in chapter 13, it's found in section 1328. Most of what's in section 523 applies in chapter 13, but not everything. So most debts that are not dischargeable, it's pretty much non-controversial. For example, if you owe domestic support, child support or alimony, sorry, you're just not getting rid of that. Or most tax debts. There are some tax debts that are dischargeable, but generally speaking, if you have a tax debt, unless it satisfies a three-part test, it's not going to be dischargeable in bankruptcy, so there won't be adversary proceedings associated with that. But there are three kinds of debts that will be discharged unless the creditor successfully challenges their discharge. They are debts incurred through fraud, debts that are the result of a breach of a fiduciary duty, and debts that are the result of doing willful and malicious harm to a person or property. Those debts will be discharged unless the creditor successfully challenges their discharge. By the way, one of the things that's different in Chapter 13 is that third one, willful harm to property, is dischargeable in Chapter 13, but it's not dischargeable in the other chapters. So in that sort of adversary proceeding, the creditors or the creditor will file an adversary complaint that initiates the adversary proceeding. And their big picture goal is to get the judge to say, sorry, that debt's not going to be discharged. Now, on the other end of the spectrum, how about an adversary proceeding to determine that a debt is dischargeable? These are less common, but occasionally they do come up. And because of some changes in policy at the Department of Education, they may be coming up a little bit more frequently. And that is an adversary proceeding that's initiated by the debtor, not a creditor, but by the debtor, to determine that a particular student debt is dischargeable. The case law on that has not been very favorable to debtors because most of those cases have ended up badly for the debtor. And that's because adversary proceedings tend to be expensive, as with any lawsuit. Their attorney gets hired to do the work and is typically going to charge by the hour. And when you're dealing with an adversary proceeding, it's impossible at the beginning of the case even to know how much time it's going to take, because a lot of it depends on what the other side does. Some adversary proceedings are resolved very quickly with a settlement. Others are pitched battles that go on for years, and I've got one right now that's been going on for about 4 years. So the problem here is the expense. And so if you are in a position to be able to discharge a student debt, you probably are not in the position to hire an attorney, because the test that's used to determine whether a student debt is dischargeable or not is something that was established in a New York case called In re Brunner, or sometimes pronounced Brunner. And that has to do with whether having to repay the student debt would create an undue hardship on the debtor. It's a 3-part test. Well, if you can establish that it's an undue hardship, you don't have the money to hire an attorney, so you're up against some sophisticated attorneys. And generally speaking, the case law has not been favorable to debtors. But just recently, the Department of Education has relaxed some of the standards and made it less complicated to establish that you have an undue hardship, so it might not be as expensive to hire an attorney. In any event, those are the two types of adversary proceedings that we see with some regularity. Most of the time, though, it's an adversary proceeding to challenge the discharge of a debt, and most of the time that is under a theory of fraud. So the standards in establishing that vary from concept to concept. So in that sense, adversary proceedings are not all cookie cutter the same. But on the other hand, they are all the same in that there's a certain structure to any adversary proceeding, just as there's a certain structure to a lawsuit in, say, the federal district court or in the California Superior Court.